Welcome everyone to Program Accessibility and Structural Accessibility Public Facilities, exploring Title II with Jason Jones. And take it away, Jason.
Thank you so much, Lorna. I appreciate the opportunity, and I appreciate the opportunity to speak to a great group of people. Libraries have played an important role in my life over the years, from summer reading programs to a great place to take our children when they were little. So I really appreciate the opportunity to talk to you a little bit today about program accessibility and structural accessibility in public facilities. I am Jason Jones. I am the Southeast ADA representative for Kentucky. So I deal with all things dealing with the Americans with Disabilities Act. I also work as a program director at the University of Kentucky's Human Development Institute, where I've been for about 5-6 years now. And before that, I was with state government at the Office of Vocational Rehabilitation for about 15 years. So I've been all around. Most of my life has been in the public sector, not in the private sector. So this presentation is kind of where I've lived most of my sort of career, I guess, if for lack of a better term. I did come out of I used to write for the Herald Leader and worked in television for a little while too. As my degrees in mass communications. So, and as Lauren said, if you have any questions or comments during our presentation here, feel free to let me know, and we'll have a discussion. I prefer these things in person, but I also like the accessibility and the just the portability of obviously doing it this way. So again, if you need anything, just let me know. All right. Okay, so we're going to talk today about exploring Title II. Just to give you a heads up, there are 5 titles of the Americans with Disabilities Act. Okay, the ADA was signed into law in July of 1990. I am a C4 quadriplegic, which means I'm paralyzed from the shoulders down. And I was actually injured in April of that year. So my journey as a person with a disability began almost exactly the same time as the United States adopted this legislation. And the thing I like to say about this legislation, in the world of politics today, we don't see it very much, but it was almost a unanimously passed bill signed into law by then President George Bush, the first George Bush, the father. And it was sponsored by a Democrat. And so it was this very, it was time for this to happen. And they felt like it was, and the entire Congress and a Senate passed it almost unanimously. Okay, so there are 5 titles at ADA. First one is employment. All right, and that's non-public employment, that's private employment. Second is where we're going to spend all of our time today. That's accessibility in public entities. That's your government, all right? Physical and program accessibility, state, local government, federal government. It's covered, it's covered under an older law. Title III is accessibility in business. This is what we tend to think about when we think of the ADA. It's your physical and program accessibility and sort of your retail world, your malls, your restaurants, your hotels, places of business. That's what we think of with accessible parking usually, ramps, accessible bathrooms, that kind of stuff. Ease of access. And 4 is telecommunications. And 5 is just a sort of a miscellaneous catch-all. Okay. All right. So let's dive right in with program accessibility. So the law says a public entity may not deny the benefits of its programs, activities, and services to individuals with disabilities because its facilities are inaccessible. In other words, you can't just say, sorry, we're not accessible. You can't do what we do here. Okay? A public entity's service, programs, or activities, when viewed in their entirety, must be readily accessible to and usable by individuals with disabilities. The standard known as program accessibility applies to all existing facilities of a public entity. So we're talking about programming now, right? We're not talking about a ramp to get in the building. We're talking about, is the program accessible? And obviously, if it is in a place in the building that can only be accessed by a ramp, then that would be considered program access. Okay. And facilities built before the ADA. Okay, we'll get to that. Here we go. All right. Sorry, I forgot to advance the slide. So somebody yell at me or raise your hand or throw something if I forget to do that. So grandfathered in. This is a term we hear a lot. Grandfathered in is the idea that it doesn't apply to me because this is the way we were before it happened. Okay. Well, unfortunately, there is no such thing. Facilities built before the ADA are not what's considered grandfathered in. In fact, this is something when we make inquiries to businesses and to entities in state and local governments, they say, well, we were grandfathered in. It's like, no, nothing in the ADA about grandfathered in. They may not have to do structural renovations or physically change the building to become accessible, but they are still responsible for ensuring program accessibility, right? So if you can't do it in your building, you better find a way to move it out of it. All right, that's what we're talking about. All right. So program accessibility, here are some examples, right? So some options: reassigning services to accessible locations. Just what I said before, move it to a different place, a different building, a different venue, something like that, right? Home visits. Now this is kind of weird. What would you say is a home visit? But say in your world you have available a catalog of music and someone could not get in your building. You could literally deliver to their home. That would be considered a home visit. Or if so there are probably a lot of examples with the media and the kind of stuff that you all lend out that it would it could you could almost pretty much do anything as far as a home visit goes. Purchase of equipment, all right, offering aid or assistance, which is the easiest, right? Probably the one that's the most ubiquitous. Auxiliary aids and services to ensure effective communication, right? That's going to mostly affect our deaf community. And structural change if there is no other option available. All right. So if you can't do it in any other way, then and there's some examples of those kind of things that we're talking about. So like public hearings and meetings. Here in Lexington, we do a lot of meeting in our local library because they have some really good meeting space in each of those facilities. So public hearings and meetings, they need to be accessible. If it's open to the public, it should be open to everyone. That's what the law says. Moving to an accessible location, all right? That's pretty easy. Providing an interpreter, although if there is, and we'll talk about effective communication a little further on in the presentation, but sometimes depending on how long or how much duration there is of a meeting or a program, you may need an interpreter. Providing handouts or meeting minutes in alternative formats, including Braille, large print, high contrast, that kind of stuff. Or, as we said before, going to a person's home to give them necessary information. Okay? And again, I did not advance the slide. So that's what it looked like. It was real pretty. I'm sorry y'all couldn't see that. Okay. So in its entirety, and this is important, okay? A program must be evaluated both in terms of the parts of the elements that make up the program and in terms of the way they work together as a whole, okay? Now, think about it this way. A city library has, I think here in Lexington, we have 5 or 6 branches, right? So to evaluate the accessibility and usability of the library system in its entirety, it is necessary to consider a few things, okay? Public entities are not necessarily required to make each of their existing facilities accessible or every aspect of a facility structurally accessible. This allows for both structural and non-structural methods of achieving program accessibility, right? So in the example of the library, the resources, it's necessary to consider the resources and activities provided in each library and facility, right? The operation of the library is in a system as a network, any out-of-building activities that are part of the operation of the system. So if you think of it in terms of, we have a program that's in our South branch, right? And one of our other branches is not, or the South branch is not accessible. As long as we offer that program in another branch, that would satisfy the ADA's requirement for program accessibility. Okay? So answer these questions will determine whether All the services and resources available in the system as a whole are available in accessible locations. All right. Wish I could see y'all's face. You may be bored to death right now, and I have no idea. Okay. All right. So here's an important point. All right. Unlike private entities under Title III, public entities are not required to remove barriers from every facility, even if removal is readily achievable. Okay. A public entity must make its programs, all of its programs, accessible. Physical changes to a building are only required when there is no feasible way to make the program accessible. Okay? So an example would be like parks and rec programs, that kind of stuff, where you can't physically build another field somewhere or move it to somewhere else. Okay? All right. Are there any questions? Lauren, I guess you're monitoring the chat, right?
Yeah, I'm looking at the chat. We haven't had any questions thus far, but this is a good point to remind folks. Jason would love to take your questions throughout, or even if you have comments about how the situation he's describing applies to your library. We'd love to see some activities, so chat away.
Right. So a public entity does not have to take any action that would do one of four things, right? Result in a fundamental alteration in the nature of its program or activity, which means if moving it or would completely change what it actually is, then of course you don't have to do it. Cause undue financial or administrative burdens, okay? If you don't have the staff, they can't, the ADA doesn't say you have to build or put an elevator in every old building or anything like that, because that is undue financial administrative burdens. And I know you all work in a world where funding is tight very, very often. So, okay. The undue burden determination can only be made by the head of the public entity or his or her designee, and must be accompanied by a written statement of the reason for reaching that conclusion. This is a good idea if there's ever any, because if there's ever any litigation, you need to have that written statement on file saying, this is the reason why we could not do that. And it's always a good idea to have somebody that's kind of a little more adept at the law to look at that for you and make sure that that statement is adequate. So the determination that undue burdens would result must be based on all resources available for use in the program. All right. And again, note that the public entity still must find a way to ensure access to benefits and services of the program or activity. Okay. All right, excuse me, I'm going to get a drink real quick. So, effective communication. All right. So this is really important. Government entities must provide effective means of communication to people with hearing, speech. We see a lot in cognitive disabilities, in the world of autism and those type of intellectual disabilities. So the communication must be provided in a manner that enables people with disabilities to participate in or benefit from the service or program on an equal basis, okay, with others. So unless to do so would result in a fundamental alteration, as we said before, or undue financial administrative burden, right, it must be made, okay? And again, there's that undue burden determination under that. So one of the ways of doing that is auxiliary aids, okay? And here's a couple of good examples of auxiliary aids, like someone with a hearing disability, interpreters, written materials, assistive listening devices, and technology, closed captioning, transcription services, note takers, video remote interpreting. And that's a little bit older. That's kind of what we're doing now with the text-to-speech and with Zoom and these other programs. And visual disabilities, things like Braille, audio descriptions, recordings, large prints, CDs, if anybody remembers what those are, tapes, if really anybody remembers what those are, qualified readers or physical guidance. Okay. I feel like we're flying through this. All right. So public entities must give primary consideration to the communication preference of the person with the disability. Anybody want to take a stab at what you think that means? You don't have to.
Yeah.
Right.
Well, I'll take a stab since I have a microphone. The participants in the meeting, webcams and their microphones are disabled, because sometimes that can
Okay,
be chaotic. But I guess with
sure.
their choice, that you can't just say, well, here's one accessible format and that's it. If they really need the large print option, they really need the Braille, you need to provide that choice for them. Is that correct?
That's perfect. Yep, you
Great.
pretty much did the rest of this slide. So the public entity must honor that choice unless it, again, demonstrates that another equally effective means of communication is available, okay? Or if it would change or alter the fundamental service, or again, undue financial burden, all right? So communication provided must be effective, okay? You can't say, well, we're gonna write notes for this one. You got something to say, write on a piece of paper, and somebody will sit beside you, and if there's something good being said, then they'll write it down on a piece of paper and show it to you if you are deaf or hard of hearing, right? It's probably not the most effective, right? So, and again, if undue burden does exist, entities must still provide the next best means of effective communication. And where we see this a lot is in interpreters. Interpreters are expensive, right? It's a high dollar thing, and sometimes for a 2 3 hour meeting or for a conference where you go all day or something, it begins to really cut into your budget. So we need to find a way through closed caption or open caption or whatever the means is. We need to find a way to make sure that that communication is effective, right? Because really, as a library network, that's all you do pretty much is programming, right? I mean, I shouldn't say that's all you do. I know you do a lot, but that's a big chunk of what you do. Okay. So here's some
Jason?
factors to consider. Go ahead,
Oh,
Lauren.
Jason, I just wanted to chime in with a comment from the chat that I thought was really great from Shannon. She says, you have to meet them where they are and answer as they prefer. There is no access if they cannot actually benefit from the information. So I thought that was a great
You
comment.
know what? I think we should turn Shannon's microphone on and let her do a couple slides because she's on it. That's exactly right. What's the point of putting on a program if the people are not getting anything from it? So effective communication is a two-way street. Shannon, you're 100% right. Exactly. And as people that have chosen a career that involves communication really on several levels, um, yeah, you probably want the people to know what you're trying to get to them. So that's great. So here's some factors to consider when you're talking about effective communication. And these are important. So the duration and complexity of the communication. And again, where we see this a lot in the real world, like under Title III, is like in doctors' offices, that kind of stuff. Like, and for sure, when you're having something that takes a long time, a lot of information, you want to make sure that that's communicated in a good way, which a lot of times, sometimes you can do that with transcripts, but honestly, mostly that's going to be for the deaf and hard of hearing community, probably going to be an ASL interpreter. The context of the communication, like what you're trying to get across, um, that's really important. This became a big deal under COVID because there was so much information flying around out in the world. So we wanted to make sure people got the correct information. So we wanted to have the most effective communication possible. The number, the number of people involved, right, or communication. So if you're going to have 8 people, it's better to go with something like an interpreter too. And the importance and potential impact of the communication, again, that kind of goes back to the COVID idea. All right. So now that we've talked about programming, let's talk about structural accessibility. And this is exactly what you think it is, right? Gosh, I have not been advancing the slides. Lauren, if it looks like I'm talking about something not on screen, could you yell at me or something? Sorry, got you get going here
Sure.
in my notes.
I can yell. I can holler. It'll happen.
Thank you. Thank you so much. All right, so now we're under new constructions and alterations. Now, this is really important to understand. All new construction and alteration to existing facilities, those built before the ADA, must be readily accessible to and usable by people with disabilities. The bad thing is we have seen a lot of buildings built not accessible since the ADA. And that's disheartening. And in the end, the ADA is not it's not enforceable under criminal law. Like you have to be, basically you have to be sued. It is a civil rights piece of legislation. Okay? All right. So what does that mean for existing facilities? All right. Again, facilities built before the ADA are not required to make their property structurally accessible if they can provide non-structural program accessibility to their services, programs, and activities. Okay? Now, something like this may be easier to do in Florida than it is in Kentucky. All right, you could probably make a lot or most of your programming, especially from a library or a public entity's perspective, you can make it available outside where it's accessible. Now, again, your parking and other things have to be accessible too, but this probably could be done. Not going to be done in Minnesota, all right, where you get like 3.5 days worth of summer, all right, and you can people to stand outside. So there are ways around this. If non-structural program accessibility is not possible, then structural accessibility must be provided unless it will result, again, are you sick of hearing this term yet? Undue burden or fundamental alteration. All right. So what do you think? All right. Here's an example. A public school was built in 1985. We know that the law did not come into effect until 1990. It has 5 main entrances, 3 of which are accessible, but it's about to undergo renovations on the side of the building that has one of the inaccessible entrances. By the way, does anybody recognize this school that's in the picture?
Is it Hogwarts?
It is Hogwarts.
Okay, good, because I thought it was maybe Mont Saint Michel, and I was like,
You're good. You're good. All right. So anyway, since the building already has 3 accessible entrances and was built before the ADA, it does not have to renovate that entrance to be ADA accessible. Is that true? True or false? Pop it in the chat. Right? It was built in 85. The law went into effect in 90. Already has 3 entrances into that building. Any answers? True. Lauren says true.
with a question mark. I just want to note that I'm really not sure. Carol
Right.
says it's false. Shannon says true. Susan says true. So don't leave us in suspense, Jason. What is the answer?
All right, and so don't forget, there's no such thing as grandfathered in. The fact that it was built in 85 is irrelevant when they start to do what? Renovate. Renovation's key. So if they're renovating part of the building, then it would not, grandfathered in would not exist anyway. So here's what the law says. So Carol, congratulations, you are right. Since part of the school is undergoing renovations, it is considered new construction. The part of the building, including the entrance, must be renovated to be accessible to and usable by people with disabilities. Here's why. If you take something like a school, which may have multiple entrances and multiple access points, right? You can chop that up into those sections of the building to where it's accessible. When you renovate that section of the building, it is supposed to be made accessible. Okay? So Carol, good job. You win the virtual lollipop. I'd give you a lollipop if we were. Makes me a very popular presenter usually when I'm doing it in person for that reason. I like to throw out candy. Chocolate gets rave reviews, by the way. All right. So then you got to talk about design standards. All right. So what should we do? The ADA established some minimum standards for access for people with disabilities. So these standards are reinforced by state and local laws and supported by the principles of universal design to promote usability for all. Now, so we need to know, and we need to understand that the ADA is the minimum requirement, but there is no requirement lower than that. Okay? So if a city decides to adopt their own code that goes further and says we need to be more accessible, that would be the prevailing code or the prevailing law. Nothing that does not meet up to the standard of the ADA is legal. Does that make sense? Okay, so remember, when we're talking about state and local building code, the ADA is the minimum. All right. All right. So each state has its own building code, which are based on the International Code Council, the ICC, which sets the minimum standards for each state. Okay. Some states have stricter regulations than ICC, and that's that's wonderful. For new construction or renovations to existing facilities, you must contact your building code official first and follow the most strict code. We were very lucky here in Lexington when I served on the Mayor's Council or Commission for Disabilities. We were able to secure a position to where all new plans are looked at through the perspective of the International Code and the ADA. So if you're building or renovating in Lexington and you file a permit, then it gets looked at for accessibility. Unfortunately, that's not the case everywhere. And there are some exceptions. State agencies don't have to contact their code official because they write their own building permit in the first place. Okay? And the ICC standards are always being updated. And they'll be, when they're completely updated, they'll be a little more similar to the state codes. All right? So, what do these say? All right? The Access Board is a federal agency that develops accessibility standards first. The Department of Justice actually enforces them. So, this is a question I get a lot. If you wanted to file a case saying this building is not accessible, you would start with the Department of Justice. In Lexington, you would start with the Human Rights Commission. And ultimately, if they couldn't find a remedy with the business or with the entity, then you would run it up a flagpole per se. Now, when you're dealing with state, local, government agencies, right, the Department of Justice at the federal level is the enforcement arm. All right. And the standards cover everything from signage to bathrooms to parking to a whole gamut of things. All right. And these were slightly revised, and they're now and adapted, I think 2010. And they were called the ADA Standards for Accessible Design. And again, on the local level, the Human Rights Commission is the enforcer. All right. Any questions about that? All right. And I'm going to give you a heads up. Later, I'm going to give you the phone number for the SCADA, or where you can get free advice anytime you need it. So, all right. So what do the 2010 standards say? All right. So the 2000 ADA standards related to construction, alteration, and to be complied with starting in 2012. So we're almost a decade into that, but there's been no update since then, which is pretty standard. And they're more in harmony, as we said before, with state codes, have clear illustrations and diagrams. All this information can really be found on the internet pretty easily. And they do not have a retrofit requirement, okay? Which means existing buildings that are already accessible will not be required to redo what they have already done unless they do what? New construction, renovation, all right? So in other words, if you made your building accessible before 2010, you do not have to come up to those standards unless you do something new. All right. All right. So the ADA standards for accessible design minimize compliance burdens on entities subject to more than one legal standard. All right. So you don't have to look at two things. So state and federal law mimics each other a little bit better. And again, harmonize with the federal standards, implementing the Architectural Barriers Act with the private sector model codes that are adopted by most states. All right. Okay. So safe harbor. Let's talk a little bit about, well, let me advance my slide again here. Sorry about that, Jill. Elements, element by element safe harbor, okay? So this rule includes a general safe harbor, which means the 2010 standards do not require retrofitting, like we said before, or existing buildings. Elements that cover facilities that were built or altered in compliance with the 1991 standards are not required to comply with the new ones, as we said before, and alterations to provide an accessible path of travel are required to the extent that they are not disproportionate to the original alteration, all right, which means they didn't go back and mess something up, for lack of a better term. Okay? And here is the Uniform Federal Accessibility Standards, the UFAS. which applies to all federal and federally funded facilities. And I'll send this presentation to Lauren so she can send it out to you all with all of the links and that kind of stuff on it. But standards are to be applied during the design, construction, alteration of buildings and facilities. And this is where we really find that a lot of local governments really kind of mess up. It's a lot easier to build accessible than it is to retrofit, right? So it's a lot easier to build ramp design and accessibility into a design plan than it is to go back and add something on the outside of the building or in the parking lot or have to redo the bathrooms, that kind of stuff. And unfortunately, we see this happen quite a bit. Thank you, Lauren. And you are on it. I'm going to take you to all my presentations in the future, all right?
Okay, and
Before
there's
you wait for the library.
the link that's on the slide came up with a 404 error. So that's just the general build link to the building section of the Access Board website. So we can correct that slide later for what is uploaded for people to access if we know.
Okay, great. Sorry about that.
Oh, happens all the time. No worries.
Okay. So here's an important point. So when doing new construction alterations up until that day, entities could use either the old or the UFAS, depending on which work best for them. So, but now all new construction has to fall under the 2010 ADA standards for accessible design. All right. All right. So let's talk just for a second about design priorities. Okay. There's some things to keep in mind if you're trying to decide kind of really what needs to be done first in terms of building access. Okay. Now, this should make perfectly good sense when you think about it. Getting to the door. Okay. If you can't get from your vehicle or your drop point or whatever type of transportation you use to get somewhere, you cannot get any further. Okay. If you have inaccessible entrances to your parking lot or lack of things like sidewalks, that kind of thing, if there's no accessible way to get into your parking lot, and then from your parking lot to the door of your facility, there's none of the rest of it matters. Okay. So in terms of point A to final point, whatever that may be, B, C, D, E, whatever, you have to have A right first. Okay. So we have to get to the door. We have to get from where we came from to the door of your facility. Now, second is accessing the service, right? If that's in a Title III, we think more of that as merchandise, food, services inside the establishment. For you all, it would be the many programs you have, books. It could be reading programs. It could be, a gamut of a lot of media and that kind of stuff that you have needs to be accessible. Okay, and if public bathrooms are available, and this is the absolute, with maybe a caveat of parking lot design, this is where we fall flat most of the time. Public bathrooms are available. Be sure there are accessible ones. This is the biggest violation we probably see, especially in public facilities. For some reason, bathroom standards, and the standards are not that difficult, honestly, but they are a little more than just a grab bar in a stall. There needs to be a couple more things, and there's hundreds of accessibility checks that you can to sort of make sure that your building is up to code. All right. So get to the door. Get through the door. That's another funny one too. When you think about the way we access doors and the pressure that's on the door, there's standards for all of that. How much weight it takes to be able to open the door, the width of the door, of course, those kinds of things. So those are all really important too. All right. Get to the door, get to the service, and be able to use the bathroom. All right.
Jason, I have a question actually. So you've been talking about some of the minimum things, which obviously are pretty important. Is there any sort of maximum best practice type of thing you're seeing in building design that maybe a place like a public library might want to consider?
Well, I think the biggest thing anymore, Lauren, is we're learning that lifts, like patient lifts, that kind of stuff, doesn't work well. A lot of times they, especially in older buildings, they'll try to retrofit, put that on the outside of the building where it's exposed to the weather, and they have a lot of problems with, first of all, people not knowing how to use them, not training staff well, and then being affected by the elements. So that's one thing we're trying to get away from. And the biggest thing too now is that when anything is designed, is that we think of it as universal design more than just accessibility, which means, you can put a ramp up to a door and everybody can use a ramp. There's a great cartoon, I should have included in this, but there's a great cartoon of a group of people, 9 or 10 people. Only one of those is in a wheelchair, and there's a ramp and there's steps, and they're all covered in snow. And there's a guy out that is shoveling the steps for the snow, or shoveling snow off the steps. And he says, and the person in the wheelchair says, why don't you do the ramp? And he's like, well, most people are going to use this. And they're like, well, but everybody can use the ramp if you do it first. So that's kind of the idea, is that universally designed things that affect people sort of equally, everybody can use. It's good for people with strollers. It's good for the staff moving equipment in and out, those kinds of things. But we like to build flat, and we like to build as universally designed as we can. So, and I don't see, here's the thing, practitioners probably know the best. If you have somebody that, if you have a lot of people coming into your facility that have a hard time reaching books or those kinds of things, you see it, right? So maybe the idea is to lower shelves a little bit, or just do some signage that says, if you need help reaching anything, let us know at the front desk, those kinds of things. Those are real easily implemented. Does that make sense? Does that help at all?
Yeah, that made really good sense to me. And in a moment, I'm going to share a link to a book about academic libraries that has some stuff that's really relevant for public libraries. It's called Designing Libraries for the 21st Century, and it's available as a free PDF. So I will pop that in the chat in a moment, because it does address some accessibility issues that may be relevant to public libraries, even though the intent was written for academic libraries.
And one thing I've learned over the years, and this is not just exclusive to library staff and librarians, but definitely in the library itself, most of the staff that I have ever been in touch with or engaged with are really excited about usage, right? I mean, it's kind of the point of a library. We want you to use our services. We want you to be able to check out books and videos and music, and we want you to be able to come in for readings and to bring your children in to be immersed in the educational programs and stuff. So usage is kind of what you do, right? So then why not make it as usable as possible? And I think most of the practitioners in the world of library and library arts would say, let's do that, right? And let's do that for as many people as we can, which was really kind of why I said yes, without a doubt, to doing this presentation, because you all really are about community usage of your facilities, which is amazing. So, and everybody's not like that, I've never heard a librarian say, come in if you want, if you don't, we don't care, right? That would not be the type of thing that I would be used to hearing from your group. So this is always kind of fun. I always kind of like to end quickly. We'll end with a case. This one comes from the Western District Court of Kentucky, right? So this was in 2007. This was a sort of a hallmark case. There was a lot of legislation came out of this because we never thought of this before. This does not involve libraries. I really look for library cases. I guess you guys are pretty clean, because I didn't find anything real interesting where someone was upset with the library or someone in the library system. Have you ever heard of that, Lauren? Do you know of any?
Well, I can think of one example. I believe it was maybe Brooklyn Public Library or some other branch of the New York Public Library system. When they redesigned the building, they had some areas of shelving that were not accessible because it had a very cool looking design that was certainly not thought about from an accessibility perspective. I'll see if I can find a link to that particular story.
Yeah. I don't know the details of that, but I did come across that case. So, but this one is pretty interesting. This is Smith versus the TransCore America. Can anybody guess what TransCore America does? I'm about to tell you. They operate prisons. Yay, right? So Jake Dean Smith, right, was a man who was incarcerated and who described himself as handicapped, not the word we like to use, refer person first language, as in person with a disability. His left leg was amputated and his right knee was what he considered very weak. All right. So TransCore was responsible for transporting Mr. Smith between jails, but allegedly did not operate an accessible bus. Okay. So they were supposed to be transporting him, right? So we're not talking specifically here about the jail itself. We're talking about transportation means. Okay. He was kept on a bus for up to 3 days. 3 days on 2 different occasions without rest. 3 days, okay? Furthermore, Mr. Smith alleged a bus operator took some of his belongings before he entered the bus and threw them away. I couldn't find what those belongings were, but, you know, who knows? Could have been drink and food, or it could have been, you know, books, who knows, magazines, whatever. So during trips between jails, Mr. Smith stayed at Christian County Jail, which allegedly also was not accessible. While there, Mr. Smith was unable to get around independently and relied on inmates to carry him to the bathroom. Carry him to the bathroom. Shower, and to get his meals. At one point, he hurt himself while trying to get into a shower on his own. Okay? So now we have an inaccessible transportation system, and we have a physical jail, right, where that is inaccessible as well. All right? So Mr. Smith filed suit, all right, without an attorney. He did this on his own. All right? I don't recommend that. He felt like he had an open and shut kind of case. All right? So he alleged under Title II, our prisons public facilities? Absolutely. All right? They're ran by the government. This is a private company. We'll talk about that and how that affects things in just a minute. Okay? He filed suit alleging that TransCore America and the Christian County Jail failed to accommodate his disability. Okay? So again, 2 people named in the suit, the actual physical place and the people that are contracted to operate the prison system. All right? So Mr. Smith also asserted claim for cruel and unusual punishment and deprivation of property under the 8th and 14th Amendment. So he says, my civil rights were violated. Okay? So this is outside the purvey of the ADA at this point. While Christian County Jail is a public entity subject to Title II, TransCore is a limited liability company, an LLC, okay, according to their website. So which more commonly would be a public accommodation subject to Title II. So if he sues them under Title II and it's a Title III case, then they'll throw that case out if it's determined. However, the court said no. They treated TransCore America as an instrumentality of the state and Title II entity. So they say the state's paying you, you're just a pass-through, right? And so you are considered a Title II entity because of the business you do and the contract you're under. Do you all believe that TransCore America should be a public entity under Title II? And usually this is, if we were in person, I'd let you raise your hand and tell me why you do or do not. Okay? I found very few people that could make the argument that it's not. Right? I mean, we've all been wrong before, Lauren. I like that. But yes, it is because of the nature of the contract. They do operate as a Title II facility. All right. So here's the issues. Yeah, I like Shane. I like how you're participating. Yeah, and Alicia. I sometimes feel like us 3 are the only ones in there. You and Lauren and Shannon. Just kidding. So whether Mr. Smith has a claim against TransCore America and the Christian County Jail for failing to accommodate his disability under the ADA. First is the ADA issue, right? The cruel and unusual punishment under Bill of Rights or under the amendments to the Constitution, whether Mr. Smith has a claim against just specifically Christian County, and whether Mr. Smith has a claim against TransCore America for deprivation of property. All right, and this is where he claims that a guard basically stole his stuff and threw it away. All right, so 3 things. So consider this. So the ADA, as we've said before, prohibits public entities from discriminating against individuals who have a disability in operation of services, programs, and activities. State and local prisons are public entities, right? So he asserts the TransCore America and Christian County failed to accommodate his disability in providing the services they offer. Kind of a weird thing to think of prison as a service. It is. It is not one that you get a choice of whether or not to participate in, but it still is a service, okay? The 14th Amendment Due Process Clause protects pretrial detainees like Mr. Smith from cruel and unusual punishment. All right. So the basic needs of prisoners, hygiene, are protected from intentional indifference on part of the prison officials. Mr. Smith claimed the Transcorps intentionally deprived him of his property without due process. And part of that was the making him sleep on the bus for 3 days. Okay. Or he claimed he actually didn't even sleep. All right. So here's what the court said. All right. The court said that Mr. Smith can proceed against Transcorps America and the Christian County Jail for his ADA claims, which they both settled. He won both of those cases. And he also may proceed against Christian County for cruel and unusual punishment. However, they did not permit the deprivation of property claim because he failed to show that Transcorps America refused to remedy this loss of property. He really couldn't prove it, basically. So that was what they ruled. They ruled it was that he could proceed with the cruel and unusual punishment. Last I knew, I don't think he prevailed in the cruel and unusual punishment, but he did prevail in the ADA claim. All right. Any questions? Okay, real quick. I work for the Human Development Institute, the University Center on Disability at the University of Kentucky. Here's their web address. I think we're up over 60 projects now. Great resource in every avenue. One of our programs is the SEADA, which at the Southeast level is actually ran at UK as well. So that's 9 different states are represented, and it's ran at the actual UK HDI. Okay. This is the Center for Accessible Technology, another great resource. It's a lending library where people can try equipment, that kind of stuff. They have a lot of cool things there. One thing that they have is the ability to cut the binding off a book. Before that makes you gasp, and so they can scan the book, and it's easily read using PDF or some other type of reader. Okay. And then this is the Southeast ADA Center. Oddly enough, it is a project of the Burton Bland Institute at Syracuse University, and this address just recently changed to Lexington. We are actually the home team. I need to fix that slide at some point, Lauren. I'm sorry about that, but the number is 800-949-4232. That is a free service. Now, you may get unlucky, and the call may get forwarded to me, but if I don't know the answer, I'll help you find the answer. Okay, but this is a free service. We get calls. I got a call this week about parking in a private retirement community and how that was affected in an apartment building. I've gotten a call about service animals. We get calls about all levels of accessibility. And again, this is a free service. Okay. And this is my information, Jason Jones. I'm a project coordinator. I'm a director now, but this is my personal phone number. If you have a question, feel free to call me on that. And this is my email address. You can always drop an email and say hello or say, hey, I need some help. All right. And there is an evaluation slide on here, but we do not need to do that at this time. I'm sure, Lauren, you probably have your own evaluation system. Is that correct?
Yeah, we'll be sending out some surveys after the conference, but if you have one that you need to share, for your funding authority, we can certainly do that. Let me go ahead and get that URL for everyone in the chat. We want to make sure that Jason gets the feedback he needs.
That'd be great. And I just want to personally thank you all for coming today. Again, I'm a big proponent of the library system, and hopefully I'll get to meet with you all in person one day where I'm a lot funnier. It's because I can actually see if you are glazed over or you're awake and enjoying what I'm saying. All right. Lauren, that's all I got. Any questions?
I don't think we have any. Yeah, I don't think we have any other questions, but I just wanted to thank you again for all the information you provided on this topic, because accessibility, since I started in Talking Books, has always been, a huge issue that I advocate for, and I'm sure other public library staff feel the same way. And we'll go ahead and stop the recording, but do continue the conversation with Jason. And hopefully we'll wrangle you for an in-person KDLA training sometime soon.
Sounds good. Thank you all.